regarding Section 19-201, appeal of building permits. The applicant of the appeal is Jan Longnecker, and it concerns building permits B-25035, B-25034, and B-25033, which are being appealed because of not being in conformity with zoning and/or subdivision guidelines. We're going to take comments tonight, and we've got an agenda. I hope everybody has that. First of all, we're going to do the Pledge of Allegiance. Please stand for Pledge of Allegiance. Pledge of Allegiance
to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. Okay, going to do a quick roll call here of the appeal board. I'll just go around the room, state your name and where you're from.
Donnie Rynerson, Blue Mound.
Okay.
Cheryl Carney, Pleasanton, Kansas.
Steve Miller, Cross Tracks.
Al Akers, Blue Mound Camp.
Dave Fisher, Centerville.
Dan Black, Pleasanton.
Margaret Vicker, Lacey.
Okay, so we've got 6, right? So do we have a quorum? Okay, first I'm going to read the appeal application. It's a lot of words, so bear with me. The appeal I'm reading are the first 2 building permits. There's another appeal for the 3rd building permit, which is pretty much the same. Actually, it's less wording. But I'll go through this one and then I'll add the legal description for the 3rd. So it's a notice of appeal, case number ZA25-01, pursuant to KSA 12-759D, Linn County Resolution number 95-23, Article 16, Section 19-201 of the Linn County zoning regulations and Section 2-101 of the Linn County subdivision regulations. The undersigned petitioners have been aggrieved by an order, requirement, decision, or determination of an administrative officer of Linn County, Kansas, in the enforcement of the county's zoning regulations and subdivision regulations. Hereby give notice of intention to appeal such order, requirement, decision, or determination of the Board of Zoning Appeals of Linn County, Kansas. The name and title. Okay, so number 1 in the appeal. Name and title of Administrative Officer Ben Souza, Zoning Administrator / Director of Planning and Zoning, and Jesse Walton, former Acting Zoning Administrator. Brief statement of facts. Building permits B-25033 and B-25034 are both in this amendment. There's another amendment, which is B-25035, were purportedly approved on April 17th, 2025 for the construction of a structure not in conformity with the zoning and/or subdivision regulations. Although Jan Longnecker, acting as a representative for all the petitioners, had filed an open records request, a response to which should have disclosed the building permits at or near the time they were issued. The zoning administrator did not provide a timely response disclosing the permits, nor were the permits posted on the property. Promptly upon learning of the issuance of the permits, the petitioners filed this appeal. More specifically, a request for records of building permits and building permit applications was submitted March 31st, 2025. The response dated April 18th, 2025, denied the existence of any requested documents, even though the pertinent building permit applications were date stamped April 8th, 2025, as received by Jesse Walton and approved by the same individual on April 17th, 2025. An additional KORA, or Kansas Open Records Act, request submitted on May 19th, 2025, was not fulfilled until July 8th, 2025. That response included the building permit applications from April 8th, 2025, and the building permits dated April 17th, 2025. About halfway through. Hope everybody can hear me. Okay, number 3, basis or grounds of appeal. Under the zoning regulations, the construction would require a lot of at least 10 acres. See section 5-201A. The lots to which the building permits pertain are considerably smaller than that. Therefore, the building permit should not have been issued. See zoning regulations, section 21-201. In addition, sections 1-601B and 2-301D of the subdivision regulations prohibit the issuance of a building permit for construction on land that has not been subdivided in compliance with Linn County subdivision regulations. The subject property was not subdivided in compliance with those regulations because the issuance of a minor plat was in conflict with the lot size requirements in the zoning code. See subdivision regulations section 6-201A4. Further, upon learning the information presented herein, the zoning administrator did not revoke the challenged building permits. Finally, misconduct in providing public records in a timely manner as required by KSA 45-218, the Kansas Open Records Act, justifies the filing of this appeal. The wrongful conduct of the 50-day delay from the KORA request to fulfillment resulted in a 60-day deadline for appeals to the Board of Zoning Appeals to pass the issuance of the building permits were considered as a discrete act. It was not a discrete act, however, but a course of conduct decision that was included withholding requested records beyond the required response date. That course of conduct was not completely decided until the existence of the building permit application permits as disclosed on July 8th, 2025. Therefore, this appeal is timely as to those permits. Number 4, date administrative office decision appealed from. The building permits were issued on April 17th, 2025, but the combined decision to issue the building permits and disclose the issuance only after delay was not completed until July 8th, 2025. The decision not to revoke the building permits was made contemporaneously with or in close proximity to the filing of this appeal. Legal description of the property affected. Parcel ID 078-270-00-00-00-04-010, which is 7228 Road, Parker, Kansas, zip code 66072. And parcel ID 078 270 00 0 00 04 050 7898 West 1700 Road, Parker, Kansas. Then I'm going to read the legal description for the third piece. Parcel ID 078-27-00-000-004.060 7982 West 1700 Road, Parker, Kansas, 66072. Current zoning of all properties agricultural. And then it just has an acknowledgement. I acknowledge the information contained in this application to be true and accurate to the best of my knowledge. And I understand that making this application, I authorize and permit the Board of Zoning Appeals or its agent to view my property for purposes granting or denying any requests. And we have eight signatures on that. Okay, so there's the appeal. I'm going to do a quiz on the property description. Just kidding. Okay, so now we're going to give both the applicant and the permit request a representative from each to explain their case in 10 minutes. So who would like to speak for the appeal applicant presentation?
I have some handout for you guys.
Hold on, real quick. Who are you and where are you from?
Sure. My name is Nathan Howard. I actually am a landowner directly across from the property in question.
Okay, thank you.
Can I hand these out quick? This is just some key regulations on what we talked about in the presentation.
What's your name again? Nathan? Thanks, Nathan.
What's your address?
I actually, my home address is in Lewisburg. The property in question is right across the street.
Does it have an address
The property.
that you're,
In the apartment.
yes, sir.
It doesn't. Address as far as mailing address. It's always an address. All right, good evening. Like I said, my name is Nathan Howard. I'm one of the neighboring landowners that appeal the issuance of building permits. In Sunshine Meadow subdivision, I'm speaking for all the landowners. You guys should have a list of all the people who filed the appeal, and we've got 26 of us. Our appeal is straightforward. Building permits were issued for these homes on parcels smaller than 10 acres in an agricultural district. The Linn County zoning and subdivision regulations make it perfectly clear that such lots cannot lawfully be developed for residential use. Permits therefore violate both sets of regulations and hereby must be revoked. First, the building permits violate the zoning regulations. The zoning regulations impose a 10-acre minimum for dwellings in the agricultural zoning districts where these lots are located. Section 5-201A of the zoning regulations state, quote, single-family dwellings and accessory dwelling units where the land is used or intended to be used only for agricultural purposes, except that the tract on which the dwellings may be placed shall not be less than 10 acres. These lots are less than 10 acres. This is the foundation of Linn County's agricultural district. It preserves rural character, prevents scattered developments, and ensures that the residences are compatible with agricultural operations. Here, Sunshine Meadows lots are far smaller, some just a few acres. Issuing permits for dwellings on such tracts directly contradicts the minimum requirements. If the 10-acre rule is ignored here, it undermines the entire zoning scheme and opens the door to widespread fragmentation of the agricultural land in Linn County. Section 5-701, zoning regulations, further enforces the 10-acre rule. It provides Quote, following the effective date of these regulations, no parcel, lot, or tract of land less than 10 acres in an area shall be zoned as agricultural. This provision prevents the agricultural district from being hollowed out by small lot residential developments. Yet, Sunshine Meadows plat created sub 10 acre lots and treated them as though they could remain within an agricultural district in Linn County. That is exactly what section 5-701 forbids. If this practice is accepted, any landowner in the county can subdivide into smaller tracts and simply label them agriculture, even though the lots no longer function agricultural. That is the county's ability to plan for orderly growth. The fact that the lots are less than 10 acres means the building permits are hereby invalid. Section 41-201 of the zoning regulations provides, quote, no building permit shall be issued for any building or structure unless the same is in conformity with the provisions of these regulations and the subdivision regulations of the county. This safeguard ensures permits are lawful. It requires the zoning administrator to check not just whether the plat exists, but whether it complies with zoning and subdivision rules. Here, the lots were not compliant, yet permits were still granted. That decision directly violates section 21-201. Second, the building permits violate the subdivision regulations themselves. Subdivision regulations must be complied with before building permits can be issued by the county. Subdivision regulation 1-601B states, quote, no building or zoning permit, shall hereafter be issued for construction on any land that has not been subdivided in compliance with these regulations. And 2-301 subsection D adds, quote, no building permit shall be issued by the county for construction on any land subject to these regulations until there has been compliance with all of the provisions of these regulations. These provisions are crystal clear. It cannot be issued unless the subdivision process was lawful. Sunshine Meadows did not qualify as a lawful subdivision because of my next point. Sunshine Meadows lots are the result of misuse of the minor plat process. Subdivision regulation 6-201A4 prohibits the minor plat process, quote, where the proposed plat would conflict with the zoning regulations, including the minimum lot size requirements. That is exactly what has happened here. The developer used the minor plat shortcut to create lots that are smaller than the 10-acre minimum required by regulation. By law, that procedure was off limits. Once the subdivision process itself was effective, every permit issued thereafter on the lot was also effective. Allowing this mistake to stand would create a dangerous precedent. Any landowner could evade the 10-acre requirement by pushing a minor plat through and applying for permits at a later date. That would render the zoning rules absolutely meaningless to its citizens. You're asking why this matters. These are not technicalities. The heart of Linn County's land use framework. The 10-acre minimum agricultural district protects the rural land, ensures compatibility with farming operations, and channels residential development into the appropriate areas. If permits on these lots are allowed, it will invite further fragmentation of Linn County's farmland and encourage other landowners to see similar end-arounds from the regulations. The result will be more disputes, more neighbor conflicts, and the erosion of trust in the county's planning system. For these reasons, we respectfully request the board revoke the building permits issued for Sunshine Meadows. The permits were not lawful when issued, and the law requires the board to enforce zoning and subdivision standards as written. Members of the board, this is not about policy preference. It's about upholding the laws and regulations. The zoning and subdivision regulations say plainly no homes on tracts under 10 acres in agricultural district and no permits for non-compliant subdivisions. We ask that you apply those rules faithfully here. You revoke the permits and preserve the integrity of Linn County's zoning subdivision regulations.
We'll do questions after we hear from the other side. Okay, do we have a speaker for the permit application?
Yes, council, really over. Good morning, folks. I'm a lot behind. And I was retained by the pages. and they had one question. Was this done right? They've been in this community for a long time. Mr. Page, you counted up all the boards, all the commissions, all the time spent as commissioner. 85 years this man has spent serving this county. And he didn't come to me asking me, how can we push this through? Is there any kind of trick we can pull to get this done? He goes, I want to do this right, did we do it right? And so we did our homework and we dug through the regulation. And it was done right. What this gentleman is referencing in the zoning code, it's not that simple. It's not just a 10-acre dwelling. And no, I grew up in a farming community on the Missouri side. I get it. Time to change, and sometimes that can cause friction, right? But the comprehensive plan, if you read it, what it's there to do is promote the development and betterment of Linn County. It's a guide, and it's not a strict set of rules. And what Mr. Page is trying to do here is exactly in line with what the county wants to happen here. These are quality bills, bringing in quality families. More families in Linn County need homes like this. I understand that there was a snafu about getting notice of these permits from the body for request. I get that, sympathize with that. We're not going to stand up here and say they were untimely because we want to talk about the merits. And so we went through the zoning code and we went through the administrative code, and we could not find any errors in the process. So what I'm standing up here to do is a little bit to defend mine, because as a person, he doesn't deserve to be dragged through the mud. He's just trying to do what he does for the community. But mostly I'm up here to hopefully give you guys that you got a second set of eyes on this thing, and nobody did anything wrong. There was a little trouble with the core request. I'm not going to ask you to deny these folks just because they missed the appeal deadline. I want you to instead look at the merits and hopefully agree with me that everything was done.
Thank you. Okay, now we're gonna, does anybody on the committee have any questions for Mr. Howard? How about any questions for Mr. Oppenheimer?
Yes.
Okay, being no questions, we're going to move on to public comment. How many people in the gallery there would like to speak? Can you raise your hand if you'd like to speak? Nobody wants to speak? Jan, would you like to speak? So you can approach the podium, tell them who you are, tell them your position, and you've got five minutes.
I'm Jan Longenecker. I'm one of the landowners involved in this appeal. We have no problem with growth. Growth is part of the comprehensive plan. If you read the comprehensive plan, it says controlled growth. We don't just want unimpeded growth randomly throughout the county. Zoning is unnecessary without those counties out west where they have very little or no growth. Some of them don't have zoning. But once you get zoning, or once you get growth, then you have to control it in some way. It's controlled by the planning process. And during the planning process, we identify those areas that meet the requirements for growth. And then we put them on a map. We map those areas. They're available. That map's available. You know where these areas are open for development. It's just like we want industry. But we don't want industry just everywhere, just willy-nilly running out and putting a chicken processing plant across from your house. That's why we develop industrial parks. We plan for that growth. And that's the way this is. We have planned in Linn County, it says in the comprehensive plan, we will discourage lot splits. We will try to keep our large tracts of agricultural land together. And that's the whole purpose of planning and zoning. We plan so that we don't have random, unimpeded growth that impacts your life and my life. And you don't get that growth across your house that impedes or bothers your particular lifestyle. Unimpeded growth that isn't done properly, is a problem for the agricultural landowner. We have people in this room who came down from Miami County just to get away from that kind of growth. They lived with it up there. They came down here and they depended on the zoning process to know, when I buy my 80 acres, it's safe. I'm not gonna have a residential development next to me tomorrow. If you're a cattleman, a development like this is a problem across the fence. Say this year you put your first calf heifers over there like you always do. Now you've got half a dozen dogs from a development running your first calf heifers, or you've got kids crawling over to see the new baby calf. What happens when they're injured? You're telling me there's not liability for that cattleman? You put steers out there. Any of you who've had cattle know how crazy they can be, 600 weight steers. And sure enough, there go the dogs running through the fence. And down on the highway they are. It's not fun trying to get them back in. This is real life stuff. This is not, oh, there's just a house across the street or a development across the street. This means something to the landowner. It's important that we keep our agricultural lands together. And Mr. Howard was very clear with the laws that were broken, the regulations that were ignored. We have to issue, revoke these permits.
Thank you. Okay, now we've got an opportunity for either Mr. Howard.
Point of order, point of order. Just make sure there's no other public comment, please.
Say that again.
Somebody else wanting.
Oh, somebody else want to speak?
You want to go for it? You can. I'll let you. I'll go after you. Yeah. Did you want to go?
What did we do? What did we do? Skip you?
Yeah.
Hang on.
I
Sorry about that,
didn't
Ben.
make it to the agenda, so I figured I would just add myself into public comment.
No, yeah, I messed up on the agenda. So let's hold public comment for a minute. Let's let Ben speak so we can get back on track. And then we'll get back to the agenda and we'll come back to public comment.
Am I on there? Yeah.
You are. You did get on there. Go ahead and speak.
Sorry, Ben.
So can you state your name and your position for me, please?
Yeah. I'm up here. I've been to the Linn County Planning and Zoning Director, here to speak on the staff reports for this. The applicant, Jan Longnecker, 7596 West 160 Road, Parker, Kansas 66072. Requesting action to revoke building permits B25-035, B25-034, B25-033. The location is West 700 Road, Parker, Kansas 66072. Analysis will be is M&M Ventures LLC filed for 3 separate building permits that were granted by the Planning and Zoning Director. Buildings that were being permitted met the Linn County requirements. Fees were paid in full. Building permits, staff recommendation and findings. Building permits in Article 21, Section 21-9 of Linn County Regulations states, in the event of a refusal to issue a building permit, the applicant shall have the right to a hearing by the Board of Zoning Appeals. Appeals shall only be permitted by the payment of the required filing fees, or permitted by the payment of the filing fees. Zoning Appeals Section 92 states the Board of Zoning Appeals shall have the power to hear and decide appeals where it is alleged there is an error in any order, requirements, decisions, or determination made by the zoning administrator in the enforcement of these regulations. A. Appeals to the board may be taken by the person aggrieved or by any officer, department, or bureau of government affected by the decision of the zoning administrator. Such appeals shall be filed with the zoning administrator within 60 days after the ruling has been made by the zoning administrator. The zoning administrator shall transmit to the secretary of the board all papers continuing the record upon which the action appealed from is taken. B, the appeal stays all proceeds in furtherance of the action appealed from unless the zoning administrator certifies to the board after the notice of appeal has been filed that a stay would or in option of the zoning administrator cause imminent peril to life or property. Number 3, subdivision regulation 2101 states a decision and the zoning administrator on matters containing hereon may be appealed to the Board of Zoning Appeals. Building permits in section 2301, no building permits shall be issued by the county or for construction on any land subject to these regulations until an endorsed copy of the subdivision plat has been recorded in the office of the Register of Deeds in Linn County. A recorded plat of the subdivision of any approved lot split and applicable is available for the zoning administrator examination. Required public improvements have been installed or guaranteed in accordance with the provision of these regulations. There have been compliance with all of the provisions of these regulations, the conditions of plat approval, and all other applicable state and local laws in effect at the time of the subdivision of land. All regulations were compliant. So, the issuing of the permit was done to the standard of Linn County subdivision regulations. Building permits had its own appeal process that was stated section 21.9. If the writer wanted to appeal of the building permits to go before the zoning board, the writer would have put section 21.9 building permits appeal in for just building permits. These regulations were approved by the Linn County Commissioner. The standards that should apply are listed in Article 21 and with proper findings as required in Golden versus the City of Overland Park. Staff recommends denial of application. Then to the planning and zoning director.
Thank you, Bill. Okay, so there's some more public comment out there. Anybody else? All right.
My name is Caitlin Howard. Nathan Howard is my uncle. I rent a house directly south of the property. It's my grandparents' farm. And I just wanted to briefly speak on like the quality of the agricultural land there, just kind of paint a picture. My uncle's property is directly east. He has cattle over there. I have horses, I have chickens. There's a really nice creek that runs from his property onto my property that feeds quality deer. I remember at the very beginning, it was kind of questionable if like septic tanks were gonna ruin quality of water there. So it's a really nice area. It's not meant for subdivisions.
Okay, thank you. Yes.
Name is Melissa Burtz, and I live at 20284 Hadsell Road. I rent the pasture on the west side of the subdivision area. And as a born and raised Linn Countyan,
I've moved away and I came back and I just recently retired from Prairie View School District. I know initially when we were discussing whether or not this property would be suitable for any type of subdivisions, the agricultural land issue was brought up, especially with the USDA Soil Conservation Service, and whether or not this land was suitable for buildings, whether that be septic tanks, road issues, all of those things were initially brought before and in discussion in previous notes. I think you would be able to find that in the public minutes when this was initially challenged. The point I want to make is if we allow this to go through, and we do need to be concerned because points have been made that dates were not followed, rules were not followed. But what happens when those aren't followed? Well, I'm going to review or refer back to the comprehensive plan. Objective 3, mobility and infrastructure. We will have well-connected, maintained roads that effectively transport people and goods and provide and to minimize flooding and to provide public safety. How many of you sitting here this evening have driven on Blacktop Road 1077 that this land is placed on? 1077 was a gravel road when I grew up. It's now a blacktop. It is an unmarked blacktop, but it was blacktopped because we needed a route for emergency vehicles to be able to get from the west side of the county to the east side of the county, and especially Highway 7, as quickly as possible. Not only does it provide for our ambulance, fire, and police services to travel quickly along that road, but it also is a major agricultural thoroughfare. Agriculture is our #1 industry in this county. Currently, with the proposed plating and zoning of the property, there would be 3 entrances onto Blacktop 1077, an unmarked blacktop, within a short distance. As a public educator, I can tell you I'm not sure about how many school bus stops we need to have within less than a quarter of a mile from a gravel road that crosses over 1077. Currently, right now, if we would talk to our county commissioners and to our public road employees, we are not even able to keep up with 1077 right now. The repairs are all over the place. We have potholes, we have an increased amount of agricultural traffic, and I am extremely concerned about the safety of the residents who live along that road, our public servants who use that road to travel from west to east. If we have additional entrances onto this blacktop road, it is a serious major concern. And we have failed in the past to identify a lot of those kinds of things, and it has been brought before the board this evening that we did not follow protocol and how these plats and subdivisions were issued in a timely manner. And so I encourage you to really look at the consequences of what is going to happen here on a short area of the blacktop. It's a major concern. If you haven't driven it, you should go drive it.
Thank you. Okay, any other comments? Okay, we're going to close public comment. We now have an opportunity, 5-minute opportunity for either Mr. Howard for a rebuttal. If you'd like to say something?
I would. just to follow up, I think we've made our case pretty clear as far as the regulations and policies of Linn County that were not followed during this process. One thing I'd like to bring up, and most of you on this board are new, that this isn't the first time this is coming to light. This started almost 2 years ago, before this board. Some of you guys, most of you weren't here. Where the property in question was offered as a subdivision, and this board denied it. Flat out denied a subdivision. We go forward, all of a sudden, without a vote or anything, a minor plat's issued. So let's talk, I just want to talk 1 minute about the zoning. We've talked about the agricultural district and zoning and residential and all that stuff. When the minor plat was issued for this property, it states on the bottom that the proposed zoning for this property is countryside. They were proposing for the zoning to change on this. It says right here on the very bottom of the minor plat, the proposed zoning is countryside. Hasn't been approved. Zoning hasn't been changed. It's still agricultural. I think it's pretty clear. Appreciate you guys' time.
Keep it brief, folks. Leo Oppenheimer for the pages. Folks, what I really think is happening here is these folks didn't get the information they asked for quickly. And they started to feel like something was being hidden from them, like something was happening behind the scenes, like there's a conspiracy here over a 5-lot subdivision of quality homes. I can understand that. I can see where they're coming from. But when you dig into the details, like is it Souza?
Souza, yes.
Mr. Souza did, he's absolutely right. Every box was checked. Every I was dotted, every T was crossed. And so they're looking for conspiracy. They're looking for that y'all are hiding something. And I don't know how else we can show them that you're not, other than Mr. Souza's report and the permit and the granting of the permits themselves, right? Also, ma'am here had a lot to say about Road 1077. This is Road 1700. So I'm not sure where she's talking about, but it's not our road.
1700 is the blacktop.
All right, we didn't add 3 curb cuts. We didn't do a lot of the things she mentioned. And so it seems to be a problem of misinformation, folks talking past each other, which is why we have these public forums. And so this is why we do it. I hope that everybody here listen to Mr. Souza's report, listen to me, and listen to the opposition, and goes home and does their homework and feels comfortable that everything was done here right. I don't want to get into the fact you all missed the deadline, because what I want you to do is get in there and see they did it right so that the pages can get on with their project, folks. This has completely disrupted their lives. This man has dedicated his life to this community. And now to catch this kind of flack over a trumped up conspiracy theory breaks my heart. I mean, it's ridiculous. And so I just want the board to know everything was done right. Mr. Souza, your report was absolutely spot on.
Thank you. Okay, now we'll close to public comments. The board will deliberate the issue, and we can take no more comments from the public. As I understand it, I'd ask Jacqueline to explain it to us before we just start deliberating. This is a building permit issue. The appeal is stating appeal of 3 different building permits, and what our responsibilities are there. Can you explain it to us?
Yes, sir. So, as Mr. Souza read, the regulations in the Linn County Planning and Zoning rules and regulations allow a person who is denied a building permit to appeal to the Planning and Zoning Board. If that building permit is denied, that would be the proper party to appeal the denial of a building permit. In that section, there is no opportunity for a building permit that is granted to be appealed by anyone. There's another regulation in your codes that is codified in the Kansas statutes that says that any person who is aggrieved by a decision of the Planning and Zoning Board may file an appeal. So it's my understanding that these folks are claiming that they are an aggrieved person. Aggrieved person is defined in Kansas law. And so I'm going to read a little bit of that for your consideration. An aggrieved person means that a person has standing or the right to make a legal claim or seek enforcement of a right or duty. The question of standing is one of law over which the court's scope of review is limited. The burden of establishing standing is on the party asserting it. To have standing, a plaintiff must have a sufficient stake in the outcome of an otherwise justiciable controversy in order to obtain a resolution of that controversy. A plaintiff must show that he has suffered a cognizable injury and that there is causal connection between the injury and the challenged conduct. A person's interest in the court's decision or in this body's decision is that he or she personally suffers some actual threatened injury as a result of the challenged conduct. This injury must be particularized. It must affect the plaintiff in a personal and individual way. In the case of Goldblatt versus the United Government of Wyandotte County, Kansas, Mr. Goldblatt claimed that he was an aggrieved person under the Administrative Procedure Act because he had a contract with the property owners and was not the property owner. He maintained that he was an aggrieved party who could not complete his contract because of the decision of the board. The court ultimately held that Mr. Goldblatt is not an aggrieved party because he is neither the property owner nor the business owner of the business affected by the permit. So insofar as the applicants for the appeal in this case, this body must determine whether or not they have standing or they are an aggrieved party or a proper party to bring this complaint, to bring this appeal. And then once you determine whether they are an aggrieved party, then you would determine whether the building permit ×3 were properly granted or not. If you determine that they are not an aggrieved party for purposes of review by any court, I would ask that you go ahead and say that if the court were to find otherwise, if the court were to find that they were an aggrieved party, then go ahead and decide whether or not you feel like the building permits were properly issued under your rules and regulations. So that's pretty much the process that you have to follow.
Okay, so it's not necessarily the regulations. We found that the regulations were followed. It's whether we determine whether they're an aggrieved party and we can, it's the building permit that's in question, not the regulations, is what you're saying.
So the building permits, if they were properly issued in conformity with your regulations, that is the second part of the inquiry. The first part of the inquiry is whether these people are aggrieved since they are not the property owners. In this case, building permits were granted. So the property owner on which the building permits were granted, he is not appealing because his building permits were granted. Your codes allow for that property owner to appeal the denial of a building permit. So the other way that someone can appeal is if they are an aggrieved party, and that standard is pretty high. And so you would have to determine whether any one of these people, it wouldn't necessarily have to be all of them, but if one of these people had standing or qualified as an aggrieved party, and if they do, then you get to the second part of the inquiry is whether or not the building permit was properly issued or not. And if the building permit was properly issued, then the appeal is denied. If the building permit was not properly issued, then the appeal would be granted.
Whether we determine they're aggrieved or not. So it comes down to the building permit.
If they're not an aggrieved party, then the appeal would be denied.
Clears. Any comments? Any ideas? Donnie?
I have nothing.
Okay, so is there any action that anybody wants to take here?
I'll make a motion that the permits stand as is.
Is there a second? Okay, discussion on that? Okay, it's been motioned and seconded that the permit stand as is. All in favor?
Aye.
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 Let's do a roll call. Donnie?
Aye.
Cheryl?
Aye.
Steve?
Aye.
Al?
Aye.
Dan?
Aye.
Michael? Okay, motion passes. The appeal's denied. Anything else we need to cover? Okay, hear a motion for adjournment.
I'll make a motion with adjourn.
Second? All in favor?
Thank you.